Good afternoon, guys. My name is Alena Shautsova. I'm an immigration attorney from Brooklyn, New York. In today's video, I would like to share with you some updates regarding the most recent immigration news. Well, first of all, some of you may be interested to find out that the United States Supreme Court ruled that for the notice to appear to stop the time for somebody who would like to file for cancellation of removal, the notice to appear must be one document. It has to be one document. What they're talking about is the situation when a person, let's say, got caught by the immigration at the border, immigration authorities, and was provided a notice to appear without the specific time and place and date. Usually it's like time and date, TBD, to be determined, and later was served with notice of a hearing that actually had the date and time. And the government for years argued that, well, first they said that when there is a notice to appear, even if there is a TBD on it, it's effective to stop the time for cancellation of removal relief. Then they stated that if later a person was served with a notice of the hearing, it was sufficient to stop the time for the cancellation of removal. So now, United States Supreme Court ruled that it does not. Two documents cannot satisfy the requirement of the stop time rule. It is very, very significant. I would suggest that anybody who has old orders of removal would check with their lawyers if perhaps, based on this recent US Supreme Court decision, they may benefit from this decision. Usually you have 90 days to benefit from it. Now, this is not something super new because a couple of years ago, there was already a decision by a lower federal court, the same pretty much decision. But what started happening later is that Board of Immigration Appeals stated, no, it's not entirely so. Or if the government serves a notice of a hearing with a time and date, then it's sufficient to satisfy the requirements of the notification of the date and time and place of the hearing that government should provide to somebody according to the law. So there was sort of a conflict between the various courts and Board of Immigration Appeals as to what and how this situation should be resolved. And guess what? United States Supreme Court resolved it in immigrants' favor, I would say, right? Immigrants' favor, because an immigrant now can benefit from it if he or she can show that he or she was not served with a notice to appear that had time and date, and later this immigrant now may qualify for cancellation of removal. Now, it's not for everybody. Remember, it's only for those of you who may qualify for cancellation of removal. Usually it's cancellation of removal for non-permanent residents, somebody who lived continuously in the country for 10 years, is a person of good moral character, and has a relative who will experience exceptional and unusual hardship in case of your removal. But the point is that many people would otherwise qualify for cancellation, but the time stopped. This 10 years stopped with the service of the notice to appear. So if the service of the notice to appear was defective, now you may be able to benefit from this recent US Supreme Court decision. One more thing I wanted to share with you is that USCIS is changing its policy one more time and choose a better. It's basically returning to the policy of listening to or following its prior decisions when they're ruling on extensions, requests for extensions of status. Of course, it's most relevant for those of you who are subject to employment-based immigration, extensions for H-1B, perhaps some other work visas. Usually this is the context of this situation. Previously, during the Trump administration stated that it doesn't matter what we ruled before, we're going to review the entire case again. And if we find the previous mistake, we're going to make a new decision. So now USCIS returning back to the policy that I believe was implemented first in 2004, that if USCIS decided the issue and the issue was resolved between the same parties on the same facts, they will defer to that decision rather than making a new decision. It means that it should be easier to receive extensions of status requests, okay? That's what it should mean, and I think it's a very positive change. And one more thing I wanted to share with you, that New York courts, and perhaps some other courts in the country, but because I practice in New York, of course I follow announcements regarding New York. New York courts are going to be closed, are going to remain being closed for non-detained hearings through June 11th. Okay, non-detained respondents, for non-detained respondents, hearings will be canceled through June 11th, individual and master's hearings. Now, if you're not in New York and you're in some other state, please check with your court and your attorney whether or not your hearing is going to take place. Remember, you still have to comply with the deadlines. If there is a deadline for your case, you still have to follow the deadlines, okay? It's very, very important. And when the courts are going to be reopened, I don't think anyone really knows when. Perhaps by fall, when the vaccination is going to be almost completed or sufficiently completed, and perhaps when the numbers of COVID new cases will go down significantly, then we will see that the courts will be reopening. But for now, not yet. Well, thank you very much for watching, guys. Please like, share this video, subscribe to my channel, and I hope to see you soon.